Okay, Shannon, you can put us on, please.
Okay. Go ahead.
Okay, we're back on the record in the matter of Frid versus Frid, or yeah, that's right. So I want to make sure everyone's here. I've got one phone number in. Who's at that phone number?
It's probably me, Sarah Nicole Gutwein.
Oh, okay. I thought so. All right. Ms. McCluskey, you may continue your examination.
Thank you, Your Honor. And I'm just wrapping up, so it shouldn't be long. Ms. Gutwein, Mr. Frid indicated that he was aware of and consented to Ellie enrolling in school this fall. Is that correct?
Yes, and she is officially enrolled with Cherubs at Spring Arbor University.
Okay, great. And so when does that start?
I believe it will start up in September. They go with the school schedule that Western has, but I had heard from another parent that Western's starting up in August, so I'm not 100% if she'll start up at the end of August or if it will be more beginning of September. But they said that they would send out more information as we get closer.
Great. And what does that school day or that schedule look like, if you know?
It'll be Mondays, Wednesdays, and Fridays from 9 a.m. to 11:30.
And then what would be your plan for the rest of the work day when she's not at school? Do you intend to keep the nanny?
Yeah, I had attended to.
Okay. Now, Mr. Navarre asked you some questions that related to the best interest factors, and there's just a couple I didn't hear, and he did a thorough job. So I've just got a couple questions for you. Do you have any past or current criminal charges or convictions?
No.
Okay. It sounds like you have done a good job so far, but are you willing to continue to facilitate Ellie's relationship with her father?
Yes.
Okay. And even her stepmother?
Yes.
Okay. Any domestic violence in your home or any relationships is currently going on?
No. No.
And then Mr. Frid is requesting an updated support review. You don't object to that, do you?
No.
Okay. And then just lastly, if it sounds like the Highfields therapy can happen at times outside of Mr. Frid's scheduled parenting time, would you be willing to facilitate that if it were in addition to his parenting time?
Yes.
I have no further questions at this time. Thank you.
Any further questions, Mr. Navarre?
Yes, thank you, Your Honor. Nicole, you indicated that you'd be willing to provide Mr. Frid with 10 overnights of makeup parenting time. Is that correct?
That's what we had agreed upon during COVID, yes.
All right. And if he's in agreement with that to resolve that issue, are you still in agreement with that?
Yes, I was always in agreement. It was always just my concern about how well she is doing, and given her struggle, when we first started back up, he wanted to kind of whip him out really quick, and I knew that she was going to struggle. She was struggling before COVID, and then during COVID, I mean, she didn't FaceTime with him or see him through a window or have any kind of contact at all, really, aside from his texting to see how she was doing. So I really felt like she was going to struggle, and she did. And so I just wanted to get some better foundation for her before we started adding in all of these additional times. So I do know I owe them.
Let me ask you this question, if I may. You willing to, with Mr. Frid, go back to Lifeways to get a referral to Highfields?
Yeah, I never wanted it to cancel.
Okay. And it became difficult for Mr. Frid to utilize those services on the Tuesdays and Thursdays because of the limited window of time and everything that was going on in his household at those hours of the day, correct?
From what he said, yes.
All right. And you actually facilitated that by saying, look, we'll get rid of the Tuesday, Thursday, and we'll do noon to 6 on Wednesday, correct?
It was a recommendation by the therapist in January because he felt that the time of day really mattered for how well Ellie was going to do.
Okay. And that worked out, didn't it?
To a point. I mean, she still struggled. She would do fine for a while, then she'd struggle again, but to a point.
Okay. So if Mr. Frid's available to be utilized in to have parenting time in lieu of daycare or the nanny, are you opposed to that?
I am, yes.
Okay. What about if he's willing to do that on a part-time basis? Are you opposed to that?
I am at this time because I think that it really depends on how my daughter is doing. And although he has said that we do well at pickups, we do for a majority as long as he likes to start up a conversation that sometimes I feel does not need to be started up at a pickup.
And as it relates to this preschool that you're thinking about, you've already enrolled Ellie in it, and it's Monday, Wednesday, Friday mornings, consistent with the Western School District calendar, which starts in August of 2021, this upcoming school year. Have you discussed any of that with any mental health professional about whether that's in her best interest or not?
Yeah, she was assessed by Lyle Torrent last year, and they had recommended either Cherubs or Noah's Ark Academy because it's a smaller based school. And you know, I had told Scott about this, and I originally was hoping to contact Noah's Ark, but they have discontinued their preschool. So contacted Cherubs, which actually sounds like it's going to work out better because her therapy through Jackson County ISD, her speech therapy, will be wrapped up into school as well. She coordinates with Cherubs. So
when you say she, are you talking about the individual through ISD that's providing the speech
yes.
therapy?
Yes. Cherubs is with
her
Jackson
name?
County.
What's
Erin
that?
Krieger.
Okay. And you're willing to follow and be compliant with the recommendations of ISD and Highfields and providing ongoing services for your daughter?
Yes.
So there was a period of time this year that Tori wasn't providing nanny services for Ellie, correct?
Correct.
All right. So that was what, basically January into the beginning of May, or?
Yeah, she came back the beginning of May.
Okay. Do you know when that was? She came back last month?
I can pull up the exact date. I believe it was the first week of May. I'm looking at the calendar. It might have been the second week. She had to get permission from her doctor, so to come back because they had advised her not to. I don't have that exact date, but it was. I might have emailed it to Rebecca. Hold on.
So last year, when COVID started, Scott missed about 3 months is what you had testified to of parenting time, where you agreed, both of you, that for whatever COVID related reasons, it was probably healthier for your daughter, given her compromised immune system, that he not exercise parenting time, and that was something from a health decision that the two of you had a mutual agreement on, correct?
Correct.
So during that time then, were you still allowing Tori to come in, even though she was from a different residence in a different household, into your household?
I started her back up in May when I thought that he was starting up visitations again. But he ended up not starting up visitations. And although Tori was from another residence, it's just her and herself. And I knew that they took good COVID procedures and precautions. And I felt honestly it was much safer for her to be around Tori illness-wise than be within her dad's home.
So for March, April, and some of May of last year, she was not providing services, correct?
No, I let her go in the beginning of April and she came back, I believe it was the second week of May.
So you were still allowing her into the home in March after COVID hit for approximately a month?
Yeah, the first 2 weeks of March, he did not miss because of COVID. He was ill and had children that were ill, and so he just did not get her. It wasn't until I think mid-March when COVID really picked up that he didn't get her. And at that point, I wasn't 100% sure that it was kind of one of those things where it was just kind of filling it out and not knowing what's going on. And like I said, she was far more safer than his household. I mean, I think they've had COVID touch their home like 3 times now. But you know, so then I let her go. And then when I thought she was going to be going back into his residence, I didn't see the need to keep her away.
When you say her, are you talking about your daughter?
Tori. I didn't see the need to keep Tori away if Ellie was going to be going back to her dad's, which I thought. And there was a period of time where we thought we were going to be starting visitations back up in May, and it ended up not going that way.
So when did they actually resume?
The visitations?
Yes.
June. It was in June. I believe it was the first week of June. I have it in front of me. June 9th, a Tuesday.
I have no further questions.
So remind me again, Ms. Gutwein, what days does Tori provide nannying services currently?
If Ellie doesn't have anything going on that week, I mean, she always has speech therapy or whichever, and she'll move in and out around that time. I try to have her at least a few hours every day, or depending on if we're going to be gone to Mott's, she won't come that day. It really kind of fluctuates to my needs. It fluctuates to Ellie's needs per her doctor's appointments.
So it's not necessarily a set schedule. She
No.
could provide nannying services every day in a given week, or not.
Yeah.
And which days are not, she's flexible with.
Yeah, she's very flexible to, as she puts it, whatever Ellie needs, whatever I need.
So these 10 overnights that you and Mr. Frid agreed to make up, is there any reason those couldn't be done during the week as opposed to on a weekend?
They could. The only reason why I was hesitant was because of Ellie's struggles.
Those were the only questions I had. Any follow-up by either counsel?
No, Your Honor.
No, Your Honor. Thank you.
So does that conclude the proofs, or do you have some rebuttal, Mr. Navarre?
No, that concludes proofs, Your Honor.
All right, then I guess we're ready for arguments. Mr. Navarre, you get to go first.
Thank you, Judge. Judge, we have a young girl who has some medical challenges. There may be some behavioral challenges. Parties are trying to work to get a handle on those, get them assessed, take the appropriate steps as parents to promote what's in her best interest. My client's position is that it's in Ellie's best interest to spend more time with him. There's a statutory presumption that it furthers her best interest to be with her father, to be with a parent, as opposed to a third party. From his testimony, the only modification of parenting time that's really occurred was changing a 3-hour block on Tuesday from 5 to 8 and a 3-hour block on Thursday from 5 to 8 to a noon to 6-hour block on Wednesdays. That was working out, I think, also to facilitate my client utilizing services from Highfields. And since March of last year, he's been unemployed. He's been utilized as a primary care provider for the 4 children, with the exception of Ellie, and also that includes his stepdaughter. He testified that the children are all of young age. Natalie is 2 months younger than Ellie, and Kinley is going to be 2 in August, and he's got twin boys, Trenton and Cash, that are 1. He's available. He indicates that it's his plan to continue to be providing these services in his household. He'd like to be utilized in lieu of the nanny, even if it's on a part-time basis, to provide him with additional time with his daughter. He feels that because of the limited time and her having some challenges as she goes through the weekends, although he testified that she's doing much better, but there have been over the past maybe 3 weekends or so that she's been doing much better spending the entire weekend. There have been challenges where he calls it separation anxiety. It's not a diagnosis by any stretch of the imagination. However, there are challenges and there's behavioral outbursts that have occurred on those Saturdays after the Friday night overnight at Dad's. He feels that that's some kind of a developmental issue, possibly, but he also feels that that his daughter gets rewarded for her behavior. That every time she, creates a problem from an outburst standpoint, she gets what she wants. She gets to go back to her mom's, and he feels that she does well with the first overnight, and it would help her if he had the Wednesday overnights in the interim every week, so that it would help her with those transitions going back and forth from his house to her mom's house. And that she would become more accustomed to that, and that it would reinforce the fact that she's going to be going back to her mom's, and it would help her transition, I think, he believes, to allow him to exercise the full weekend without having these challenges. He's participated with services that have been provided to attempt to utilize the proper tools from a parenting standpoint to try to console her, redirect her, and he's willing to continue with going back to Lifeways for a referral to Highfields so that they can provide in-home services. And it was testified by Amy Schwartz that there was a possibility that they could have and provide services through Highfields, although it wouldn't be her, but through someone else on Saturdays. Well, that option was never provided to him, Judge, and he would have jumped at it. And he would jump at any option to have Ellie with him in his household with Highfields on any other additional time other than what his court-ordered parenting time is. Believe we have an agreement to recalculate support with a referral to the front of the court. And I believe we have an agreement that she will provide the list of providers that Ellie is utilizing, and so that he can have that information, and then he can do whatever he wants to with it as far as contacting and confirming, what appointments are and communicate with those mental health professionals. It has been Nicole who's taken the lead on that. I think in the past, either because of my client's employment or her preference, but he wants to be, as a joint legal custodial parent, involved in these decisions that are joint legal custodial decisions, like who the medical providers are going to be, like this preschool or daycare issues, nanny issues. He's available to provide those services as far as spending time with his daughter other than the preschool. And, he'd like to be utilized for that purpose. So, his position on the nanny, there's two things. One is it's not communicated when she's utilized, how often she's utilized, what duration, what the frequency is. All he knows is he was ordered to pay $250 a month for those services. He believes that that the services are limited and not 30 to 40 hours a week, as testified to by Nicole earlier today. And she says that if she's not providing those services, he shouldn't have to pay. There was testimony that there were 5 months that she didn't provide services, or 4 months, depending on whose testimony you put more weight in. My client says 5 and Nicole says 4, January through April. But he just finds out about it, Judge. And he indicated and testified that last year there were 3 months that the nanny wasn't utilized and when COVID started out. So Nicole tested differently. It's a matter of credibility as to where you think that should be. But in any event, his position is whatever these services are, they should be documented and substantiated before he's required to pay them. She testified that she doesn't provide a 1099 to the nanny, but that the nanny's deducting these or including these expenses in income. I don't know that, but I know that she's required legally, if this is an independent contractor who's in her employ, she's required to 1099 anything above $600 on an annual basis. And this has been ongoing for more than 3 years, as she testified. So we'd like you to take those things into consideration. We believe that we've met our burden of proof by a preponderance of the evidence that it furthers Ellie's best interest for her to have additional parenting time for her with her dad, and that should include the Wednesday overnight that we've requested. I thank you for your time and your attention and consideration in this matter and assisting in promoting the best interests of their daughter, Your Honor. Thank you.
Thank you. Ms. McCluskey?
Thank you, Your Honor. So to confirm, we do, obviously my client has agreed to the support review, obviously with the appropriate credit going to her for healthcare, going from the testimony of both parties. That was because Mr. Frid lost his job. And then there were the 2 very legitimate reasons why my client had to get healthcare. So we would obviously ask that the calculations are performed properly and she gets the proper credit for that. And of course, she does agree to the 10 overnight makeup time. So it looks like we're left with just the nanny versus the daddy daycare and the Wednesday overnight. So when this motion has been pending for some time because of COVID and then with the LGAL being appointed and that funding running out. So in Mr. Frid's motion, he didn't request to be able to provide daycare for Ellie, but that obviously that request has been raised. So we would point out to the court that it's our opinion that requesting an additional overnight and 5 full weekdays with the child is actually a change in the established custodial environment. My client is the primary physical custodian, and that would flip-flop that custody arrangement. So Mr. Frid's burden, of course, would be clear and convincing evidence at that point. And we do not believe he's even met his burden by preponderance of the evidence. There's nothing supporting a change only to the extent of adding an overnight. In fact, the child is, the testimony from everyone established that the child is still struggling with overnights. And regardless of what the cause of that is, and that has yet to be determined, and can only be determined by probably a professional. The fact is even Mr. Frid's testimony established that there are behavioral issues that exist. And he himself continues to call my client to come and get Ellie. And so I thought it interesting that Mr. Navarre just noted that it's Mr. Frid's position that Ellie is being rewarded for this behavior because she, has the behaviors and gets to go home to mom. But both parties' testimony established that it's Mr. Frid calling my client, asking her to pick the child up. That's not my client reaching out. So that's interesting to note. The daddy daycare, it's my client's understanding that Mr. Frid still intends to go back to work. He's obviously still on the enhanced unemployment benefits. So there's nothing to suggest that he really does intend to stay home. So what happens when those benefits run out? Mr. Frid does have to go back to work. Ellie will be in a position where she'll have to go back to the nanny or start over with a stranger, and that's just not appropriate. Mr. Frid's suggestion or solution for strengthening his bond with Ellie is to damage, for lack of a better word, the bond between Ellie and her mother and the bond between Ellie and the nanny who's cared for her since day one. And the testimony established goes above and beyond going to appointments to make sure Ellie's needs are met. Arguably, she is more involved in Ellie's care and her medical needs than Mr. Frid himself. We understand that employment was an issue in the past, but he's just been non-existent in that respect with Ellie. Ms. Swartz's testimony established that while Mr. Navarre's closing would suggest that Mr. Frid was engaged in counseling, that did not bear out in Ms. Swartz's testimony. She testified that he was inconsistent to the extent that she had to discuss the fact that it needed to be consistent with him. And then he canceled based on no legitimate scheduling issue. She testified that they would have gone above and beyond to accommodate his needs and would have come to the home. So his reasoning for discontinuing what appeared to be the most appropriate service right now just doesn't bear out. So in effect, the testimony established that it was the opposite of Mr. Frid being engaged. So again, it appears that the Wednesday overnight is one of our only two issues. And again, it's our argument that especially in addition to the suggestion of the quote unquote daddy daycare, that is a change in the established custodial environment. In the nanny, there's just no legitimate reason to remove Ellie from this woman who she's extremely bonded with, on top of the fact that Mr. Frid's initial argument was that Ellie needed to be socialized. And now that's a moving target because Ellie is going to school. So he's looking for a different excuse to get rid of the nanny. And it's my client's position that it's only because of the cost. If Mr. Frid wanted printouts or confirmation of the nanny's expenses or the nanny's cost each month or yearly, he should have asked that when this was included in the divorce judgment in 2019. I'm not sure why that issue is being raised at this time. He has gotten confirmation of that cost. So we would ask, obviously we agree to the updated support review and the makeups, the overnight makeups. So we would ask the court deny the discharge of the nanny and the rather absurd daddy daycare option with my client doing all of the transport. We'd also ask that the court deny the request for the Wednesday overnights. And actually, we'd ask that the court order the counseling, as obviously it's beneficial. It's probably our only option to get to the bottom of these behaviors. There is no cost to the parties. And then actually set the matter for maybe a status review or status conference in 60, 90 days to see how Ellie is doing with the counseling and with parenting time, and maybe entertain overnight parenting time at that juncture. Thank you.
Anything further, Mr. Navarre? You're muted.
Apologize, Your Honor. Judge, I think it's really not a solid argument to say that the requested change, which we've asked for, in expanding my client's parenting time with his daughter changes the established custodial environment. And, an established custodial environment is where the child resides. Clearly, the child resides with his mother or her mother. And so there's no change in the established custodial environment. And if Your Honor is considering allowing some expansion, which would be in lieu of the nanny or some other daycare, certainly we would welcome that. There are countless orders that provide, if there's going to be a 4-hour block of time, a right of first refusal. That doesn't change an established custodial environment in those cases. And to argue that it does, I think, does not hold up from a factual and legal standpoint. So we believe that our burden of proof is by a preponderance of the evidence. We believe that we've met that. We believe that it's in Ellie's best interest to have the additional overnights and help her transition to being more acceptable and from a behavioral standpoint, to have fewer problems on a weekend where there's 2 consecutive overnights. We feel that really makes logical sense and would facilitate that. That's why my client's asking for it. My client has no objections to an ordering both parties to go to Lifeways, to get a referral to Highfields for services to be provided for Ellie and my client's home, so that we can continue to make progress on helping to get the proper tools and the time to assist this young girl in transitioning from one household to the next for purposes of seeing her father.
All right, thank you. So we've got a child that in mom's home is an only child and gets plenty of attention as an only child, either from mom or from the nanny, and sometimes from both. And in dad's home, she's not an only child. There's another 3-year-old or close to 3-year-old, very close in age to her. There's a 2-year-old, and there's 1-year-old twins. I'm not shocked that dad struggled with Highfield's appointments, focusing on Ellie, when in fact he's simultaneously trying to care for 4 other children. That just, at least on a Zoom call, isn't going to work. I think the only way that kind of therapy is going to work is for the therapist to come in the home. Dad's caring for Ellie when he's caring for these other siblings. That should be the exact environment in which the therapist is assisting. And yeah, I mean, that's going to happen. Whenever dad's caring for Ellie, in addition to the others, his attention's going to be divided. So how do we get Ellie to the point where she fits in with this? What I would like to do is the 10 overnights are agreed upon, but they can't be tacked on to another weekend when the child struggles staying more than one night, even now. I want to see this happen during the week. There's a dual benefit. One, it's just one overnight as opposed to tacked on to others. The other benefit is it can be scheduled, Highfields can be scheduled to be there. Instead of making a special appointment on a weekend when I'm guessing Mr. Frid's current wife is going to be there as well. Let's have it evaluated at a time when focus can be on dad, Ellie, and the other kids in what would be the normal environment that he's trying to deal with her in. I am not inclined to change overnight based on the testimony I've heard, or to change the number of overnights that dad gets. I have several reasons for that. One is currently with the situation that's existed And even with the most recent 3 weekends in a row, she couldn't handle the whole time. Giving dad additional overnights at a time when the child hasn't been spending the ordered amount of overnights just doesn't make sense. Why would I expand parenting time at a time when the full amount of parenting time isn't being exercised? Another reason, though, is I'm troubled. It looks like on a number of fronts, dad's motivation is financial. I'm hearing way too many complaints about cost. I heard it about, well, let's just find another pediatrician. You got a child that's been with a good pediatrician for 3 years who's been through everything that this child has been through. Why, for the sake of cost, would you go find a brand new pediatrician? That troubles me. I'm troubled that he's concerned about having to contribute towards the nanny when the child benefits from this nanny. And I realize dad's got other expenses, and I get that when money's tight, but it bothers me that he seems to be more motivated by money than he is by a desire to spend more time with his child. The comment that was made about the daughter getting rewarded for outbursts, the only one rewarding this daughter is Mr. Frid. And I get why he's doing it. If he's caring for another 3-year-old, a 2-year-old, and 1-year-old twins, and he's got another 3-year-old who's just having a total meltdown, I can see why he's calling for help. I'd probably be calling for help. But mom's not the one rewarding this child for the outbursts. I'm impressed that mom really does want dad to be able to spend time with his daughter and have a good bond, not have these meltdowns, have a normal daddy-daughter relationship. I believe her that she wants that to happen. I don't see that she's been interfering with that. I see that she's been accommodating to it. So I don't believe that the evidence establishes a basis for expanding parenting time. But if the overnights that are being ordered to be done during the week as opposed to on the weekend work, I would like the parties to be open to discussing more time with dad. But I'm not going to order it at this point because I don't think factually it's been established. I am going to order the parties back to Highfields. I'm going to order that mom provide the list of providers as she's agreed to do. I think payment for the nanny that dad's being asked to reimburse a portion of needs to be documented. There certainly needs to be a support review. I think I said that already. Mom needs a credit for the health care. Keeping the same pediatrician is definitely in this child's best interest. I'm not going to order any daddy daycare in place of nanny daycare. I think that would be just an expansion of parenting time, which I don't believe the evidence justifies. And I think I've covered everything. Have I not, Counsel?
I don't believe you have, Judge. Respectfully, I believe that we need to address when those 10 makeup overnights are going to occur. And
yeah, they need to occur during the week. I don't have a problem with every week. And the day I was going to suggest Wednesday because that's what you suggested. If there's another day that works better for Highfields or another day that works better for both of the parties, I would be receptive to that. But if they can't agree, then let's make it on Wednesdays. So a Wednesday overnight until these 10 are made up.
And Judge, they have been exercising noon to 6 o'clock. And when would that Wednesday start?
I'm looking at a 24-hour period It could be Wednesday morning to Thursday morning. But again, let's just say 10, does 10 a.m. work for everyone?
Yeah, that'll work.
Would I
10
be, I just have one question. Would I be picking her up at 10 a.m., I'm assuming, the next day?
Yes, he would be whoever's getting the child would be responsible for the pickup. So when she's being
Okay.
returned, you would be picking her up. When he's getting her, he would be responsible. I don't really care who does the transportation. If a grandparent or a spouse or a nanny or a mother works better, I don't have a problem with that as long as it's someone the child's comfortable with.
Yeah, I only asked so that I can make that time to pick her up during work, so I can work around that pickup.
I'll say 10 o'clock, but again, if there's something that works better for the parties, you're free to change that, but you'd have to agree on it. I
Okay.
strongly encourage flexibility. It just helps. Life happens, difficulties happen. It's always better if you can do that on an accommodating basis. If you can't, we've got a fallback provision, 10 a.m. to 10 a.m.
Okay.
Does that work with you, Scott?
Yeah. Yes,
Okay.
that'll work.
I really think this is going to help, both because you'll be able to have Highfields in the home for the visit. They can, it's just easier that way. But I think as she gets used to more overnights, going those double overnights on the weekends is going to get a lot easier. I sure hope so. I think as she gets older, it's going to get easier.
I have a question, Judge. With that Wednesday being temporary right now, do we still continue the Tuesday and Thursday, or do we just do the Wednesday right now?
It is a makeup. So what's your pleasure on that, folks?
I think Ellie's going to really struggle.
Yeah, the 5 to 8 court order does not work for her anyways. She is ready to go to bed when I get her.
So I'm willing to weigh into that. So, do you both agree 5 to 8 is, even though that's what that order says, it's just not working for Ellie. That sounds like it's a busy time at Dad's house in any event, trying to get other kids to bed and then getting her back. It just sounds like it's a cumbersome process. So once the 10 overnights is done, how do you feel about going back to Wednesday being that, but it being 1 to 6 as opposed to 5 to 8? And again, I am very sympathetic to what Mom was saying about getting that canceled at the last minute. She needs dependability on this.
Your Honor, I never did that. I never did that. I don't know what she's lying about that.
I found her to be very credible. So a permanent change to a midweek, once these 10 overnights are satisfied, from 1 p.m. to, when do you guys eat?
5:30, 5:30.
So 1 to 6:30, does that work?
Yeah, that'll work.
Does that get her home in time to settle her down, Ms. Gutwein?
Are we talking? I'm sorry, I'm getting a little confused as to how this is. So the 1 to, you said 6:30 on Wednesdays, or after the overnight Wednesdays are done, or?
After the overnight Wednesdays, obviously, if she's there overnight, that doesn't apply.
Yeah, no.
But I'm looking at something to replace the 5 to 8 slots that just aren't working for anybody.
Okay, and in the meantime, do we do the 5 to 8 then, or no?
No, we We would dispense with
Okay,
those.
I'm sorry. Yeah, okay. I was just wanting to make sure I understand. But yeah, 1 to 6:30 is fine.
Judge, can I
Let's
make a
do that.
friendly reminder that it was 6 hours that we're trying to replace 2 3-hour blocks? And if they were doing noon to 6, but if we wanted to move that to 12:30 to 6:30, I think that would replace the 6 hours that we're talking
Yeah,
about.
I don't want them to lose time, so that makes sense, 12:30 to 6:30. And I moved it a half hour just if they're eating at 5:30, and so they have to rush around. I think it's easier if it's more relaxed for everyone.
And Your Honor, would you like me to prepare that order?
Would you please?
Actually,
I will,
before-
Your Honor.
I'm
I'll send
sorry. Sorry to interrupt you, Mr. Nabar. I thought of one more thing that Mr. Frid did. Well, the parties had testified to the nanny payment that Mr. Frid unilaterally stopped paying that he was court ordered to pay. Obviously, both Ms. Gutwein testified credibly about the time that the nanny did not work. And if that is the case, it looks like that was around 6 months. And I believe Mr. Frid withheld that payment for 9 months. So of course, she testified, she understands he should have a credit for when the nanny wasn't working, but there are extra months that he was in violation of the court order.
I have
My understanding was that the judge indicated that she has to document that and we can address it on those documented expenses.
Document the expense, and he's responsible to pay his share as ordered.
Thank you. That was it. Sorry. Thank you.
Okay, thank you, everyone. Have a good
Thank
day.
you, Judge. Thanks, Rebecca.
Thank
Scott, I'll talk to you offline.
All right.
Okay.